retention of a necessary way leave at Newlands Farm, Denholm by Hawick. Okay, and you should all have copies of an agenda, which was circulated. Apologies for a slight misunderstanding about the date, but it's clearly today. And just emphasis at the outset that basically this is simply a procedural meeting. It's not intended to discuss the merits or otherwise of the case. It's just allow us to move forward. And I'm conscious, obviously, that Scottish Power have asked for a hearing through Shepherd and Wedderburn, and we'll move forward on that. And there's to be no discussions on the merits of the case at all as we go through this. Okay, if we could just have, in this particular case, introductions. Murray and Moray and so Jamie, Murray and Kenny, could you just introduce yourselves and say your particular role in this case? Okay, Jamie first.
Good morning, my name's Jamie.
Sorry, I've lost the volume on that.
Is that better?
That's better, yes.
Yeah, good morning. My name's Jamie Murray, and I'm the agent acting on behalf of Laura and Helen Dogs.
Okay, thank you. I don't know, Jamie, whether you can turn your volume up a little bit. It was very indistinct when on that.
I'll see if I can do that.
That's better. That's better.
Okay.
Moray and Kenny, can you hear that better? Yes.
Yeah. Yes.
Right. Okay, that's fine. So apologies for this. I've had similar teething problems here in the office just to get things working, but it looks as if all systems are just about ready to run. Kenny, could you just introduce yourself?
Yep, sure. Name's Kenny Jackson, and I'm the Lands and Planning Officer for Scottish Power Distribution.
Right. And lastly, Moray.
I'm Murray Thompson. I'm a partner at Shepherd and Wedderburn, and I am acting for SP Distribution in the application. We're also joined by Sean Gavigan, who intends to give evidence as well. He's on the call. He's the head of delivery for overhead line investment and design.
Yes. Good morning. So I'm Sean Gavigan. I'm head of planning and design and delivery of our overhead line for our Edinburgh Borders district, where this area comes into question.
Okay, and I'm reading you loud and clear, Sean. That's
okay,
good.
Thank you.
I think all systems are set and we're ready to run. Okay, right. Okay, so just move on from that. And by way of introduction, I'm Chris Norman, the reporter appointed to deal with this particular case at Newlands Farm at Denholm. And the purpose of this meeting is simply a procedural meeting to look at the arrangements which we need to set up to have a formal hearing into the case. And I'll come on to that in a minute. I've familiarised myself with the documents that I have before me, both as submitted by Shepherd and Wedderburn and on behalf of the appellants. I don't intend to refer to anything in there at the moment. It's not the remit of today's meeting. But I've certainly familiarised that and parties' rebuttal notices on that. I've looked at the Electricity Act, in particular Schedule 4, and familiarised myself with the particular regulations against which this determination has to be made. I carried out an unaccompanied site inspection of the land about probably end of November, December now, just to simply familiarise myself with the geography of the site. And it makes it a lot clearer when I'm looking at the documents. I see the building there, the location of the cable across it, the proximity of other places round about. So I've got a background knowledge of it, but I'll certainly come on to later on in this meeting. I think I'd want an accompanied site visit as well, and we can look at that. But obviously Scottish Power Distribution have asked for a hearing here, and one of the first things I want to establish is there an update on the negotiations between the parties at this point in time, or what I've got on file. That is Shepherd and Wedderburn's statement and rebuttal comments on the appellant's statement, and the appellant's statement and rebuttal comments on Scottish Power. Is there any further development in terms of negotiations, or is the matter now clearly before me as part of this hearing? Jamie, do you want to say anything from behalf of your client?
I think it is. There has been no further negotiation carried out or discussions. So documents submitted between each party.
Okay. Right, and that's his position of Scottish Power Distribution as well. You've had no further discussions. The matter has reached the point where the way forward is through the sky. The reason I ask that, and from experience, a lot of cases like this and similar cases tend to move to the point of pressing the button to start the inquiry determination procedure, and then agreement is met. But it looks, from what I hear and what I understand, that we're looking into holding a hearing. So with that,
Sir, just sorry if I could just interrupt. Just on that point, it's the landowners have asserted their right to have a hearing in this case. It's not the position of SP Distribution that they wish the matter to proceed by a hearing, but nonetheless, that's where we are. And the engagement, there has been considerable engagement as set out in the hearing statement, but nothing further really since the hearing statement was lodged in August.
Okay, thank you for that. Right, so the next item on the agenda is participation and the structure of the hearing. What I would want to do at the hearing is understand specifically the matters in front of me, and what I'll do, I'll prepare a note of this meeting and circulate it to all parties after this pre-examination meeting, just to make sure we're all at one with this. But certain items that I need to understand is really going back to schoolboy physics about the relationship between a 33 kV line and the ability to connect to that. And I've seen from the evidence that reference is made to various locations, indeed in the borders, where Scottish Power have allowed connections to that. I want to know something about that, and certainly in an early part of the hearing itself, we'll want to just understand the technicalities of it, the problems with it, and so on. And again, I'll produce a note to this setting out what that requirement is particularly. Okay. Another matter that I would want to be clear in my mind about is the planning position of the Tweed Dogs facility at Denholm. I've seen the building, I've seen the use of the field, I've seen the types of boundary markers and so on, but certainly a copy of the planning permission for that facility and an approved plan showing the red boundary of the land which is subject to the planning permission, and a schedule of the conditions that are attached, and a schedule of the status of compliance with the planning conditions is something I'd want. Basically, it's just to understand the lawful position of the Tweed Dogs facility, if I can call it that, and that it's not a breach of planning control, and it is acting lawfully at this particular time. I also see reference to the wish of Tweed Dogs to potentially expand the facility there and offer overnight boarding care. And I think reference is made in one of the documents to the need for a much sounder electricity supply for that. What I'd like to know from my own background is there any other planning permissions extant on the site, or have discussions been made with Scottish Borders Council about a change in that facility to allow overnight boarding of dogs and so on, and hence the necessity, as suggested by the appellants, of the need for a different electricity supply. So that's basically three things there: a copy of the planning permission, a copy of any other planning permission, and a background note about discussions and aspirations of further development on that site. And that's obviously without prejudice. If it doesn't have planning permission, I'm not here as a planning reporter, but I'd just like to know from my background what the aspirations are. Is that fairly clear there? Any points to raise on that?
Yeah, it's clear.
Yeah,
okay. Another matter that I would like clarification of is the comments from parties on the DPA guidance for landowners and occupiers for the for electricity way leaves and so on. I don't know whether everyone is familiar with that document, and I'll certainly send a link with my note of the meeting. But in particular, there is a section in that document prepared by DPA entitled "The Consideration of the Necessary Way Leave Application," and it sets out the procedure adopted by DPEA, and then it talks in a paragraph in particular about the purpose and scope of the reporter's consideration. Okay, is everybody familiar with that document at this point in time?
Yes.
Jamie, Murray, Kenny, Jamie, you know that?
Yes.
Right. So in particular, what I will be asking for is comments from parties on paragraph 66 to 69, which relates to the purpose and scope of the reporter's consideration. And what I would propose to do, in the same way as has gone before, if parties could prepare that and submit it to the other party for their comments, okay? And that just gives me an understanding of the position on what is a document which is obviously relevant to my consideration of the appeal. Whilst we're just, again, talking informally, what sort of timescales do you think people could do that? Because I'm conscious that this case has been around some time, and again, I should have said at the outset, apologies for that. This is all due to the difficulties we've been working under the current regulations and the huge numbers of appeals that have come into us after lockdown started easing. So there is, had been a delay in considering this. But what I would look to do is as part of this point is agree a date for the formal hearing itself, which has to be at least 2 weeks away from here. But is it fair that everyone makes comments on paragraph 66 to 69 within 7 days of today's date, and then forward it to the other party for their final comments on that? Is that a reasonable timescale?
So we haven't actually formally exchanged documents in the case. The last letter, which was issued by the DPA, indicated that the hearing statements were to be prepared, and then the documents would follow four weeks ahead of the hearing date. Now, maybe everyone's happy to dispense with the sort of 4 week period, but just to let you know that the actual documents are still to be lodged.
Right. Well, I was wanting to come on to that, Mr. Thompson, because obviously I've got the information and statements made by yourselves, but one of the points I was going to raise is, are they suffice to rest on, or do you want a formal submission of additional documents for both parties then?
Well, we will be lodging. I mean, for example, one of the documents on which we will be relying, and I think which is directly relevant to your consideration, is the plan showing the potential diversion in the event that the necessary way leave is not granted, and that we will have to consider that in the context of expedience. But all of the documents, I think, are very helpful, and they are listed at the back of the hearing statement. So we would want them in the process, and they may be referred to on the day of the hearing itself.
Right. Mr. Murray, any points to raise on that?
I think one of the points Murray actually made in one of the statements was about evidence that weren't barred from submitting evidence that hadn't been submitted so far, and anything that was relevant to the case at the hearing. So I mean, we're happy with our documents that have been submitted, but obviously there's some more documentation to be submitted alongside that. Whether that evolves, we will see. I suppose it depends if we get comments back from Scottish Power submission of ours. I suppose it's when do we draw the line in the sand and say that's everything submitted.
Okay, well, just moving forward, we've heard from Mr. Thompson of further information coming from SP Distribution. And there's no further information coming on behalf of Tweed Dogs beyond what I've got from you, Mr. Murray.
I'm not saying that, no. I'm saying you've obviously asked for more information, but at the moment you have everything that we were going to be submitting.
Right. Well, I think in circumstances, can I ask parties to submit a concise set of all information to me? That may well be just a repeat, Mr. Murray, of what you've already given. It's obviously going to be augmented on behalf of Scottish Power Distribution, but I think I would want to be complete and absolutely sure that I have all the material I need to see before the hearing date is set, okay? If we work back from that, I mean, technically speaking, I've got to have the formal hearing 4 weeks from today, and I've got to have all the information in. I'd like to move it forward with agreement with parties, but if I'm sticking to the 4 week position, we're looking for a hearing date sometime early March.
Sir, I think there's a bit of confusion. The rules that we're using here are really the planning appeal rules, and it would be four weeks from the exchange of documents. And I think today you've asked the landowner's agent to provide further documents, which I assume will be part of their schedule of documents, and we would obviously need some time to consider those. So I think the hearing date should really follow the exchange of all of the submission of all of the documents that both parties have to provide. So I don't think the hearing can be 4 weeks from today.
Okay, so it would be, so what you suggest, Mr. Thompson, is 4 weeks from the date of receipt of all documents?
Yes.
Okay. And with that in mind, how long does either side anticipate being able to submit all documents to me?
Well, my question was, you've asked us to submit comment on paragraphs 66 to 69 of the necessary way leave.
I do, yes.
Guidance. Now, they're to be submitted to either side. Is there to be comments made against those when they're on receipt of them, or? Yes,
I would want to know either party's views on the comments made in those paragraphs.
So it's kind of still live at that point, because there's still documentation going back and forward. It's quite still fluid.
Correct.
So,
but what I would like to do is get the additional documentation from parties combined with the submission on paragraph 66 to 67, 69. I don't particularly want to spin it out. So if does it, can you say roughly from either party how long you think it would take to assemble your final hearing statement and comment on paragraph 69, 66 to 69? What's the timescale we're looking at there?
Without wishing to sound awkward here, I think the hearing statement might alter depending on what the comments on paragraph 66 to 69 come back at. So I think that would be the first port of call, that we had both submit comment on paragraph 66 to 69 and let the other side comment on those, and then draw a line in the sand for submission of the final hearing documents.
Mr. Thompson.
I was hoping to avoid, revisiting the hearing statement and the response. We've had a fairly full exchange already. I saw your comments on 66 to 69 almost as a sort of procedure notice, and we could take a week or a fortnight to provide those, and then there would be a week to comment on the other parties, and that would be that would be a sort of distinct submission, almost to augment the sort of existing hearing statements and responses you already have. I don't think these submissions on paragraph 66 to 69 need to affect the hearing statements or trigger some sort of revisal to those. And then that could be done in parallel with the documents. From a Scottish Power point of view, you haven't asked for any additional documents, and other than that particular sort of statement, we could have those with you within a week.
Mr. Murray.
Was the comment on the use of 22 kVA lines and upwards to be made today by Scottish Power, or is that something that you require a document submitted?
It's something I would wish as an agenda item for the hearing.
Right, okay. That's fine then. I mean, I think I don't have a problem with that, submitting the comment on paragraph 66 to 69 within 7 days, and then commenting within another 7 days on.
Well, Mr. Thompson.
No, we could comply with that timescale and separately submit the documents themselves, which I think, I mean, correct me if I'm wrong, I think the landowners have submitted the documents which they've referred to. They're embedded in their statement. They've got the planning permissions and the status of the conditions, etc., which you're asked for, which I think should be documents. And then we have a list of 9 documents which we'll put into process, and we can do that, as I say, within 7 days.
Okay, so to move it forward, if I set out in my note of this meeting that both parties to make comments on paragraph 66 to 69 within 7 days, and send them to me and to the opposing party, who has a further 7 days to comment. And that keeps that a separate entity. And then after that, if we get both parties' hearing statements augmented within 4 weeks, and once I've received, then we can set a hearing date. Mr. Murray.
When you say the hearing statements augmented,
well, what I mean by that, Mr. Thomas, is just the final document that you want before me, formally submitted as a hearing statement.
Well, as I said, I wasn't envisaging that we would. As I see it, you've got the hearing statement, you've got the responses from both parties. I think what you're looking for is comments on paragraph 66, 69 and the comments on the other side's statement, and then separately the documents that each side wants to rely upon. And I think from my understanding, the landowners wish to, well, you've asked them to lodge the planning permission documents this morning, and we will lodge the documents we've already given notice of, which are as listed on our hearing statement.
Yes.
So those will be lodged in 4 weeks, I think, from what you're saying.
Okay. Yeah. Mr. Murray.
Yep, that's my understanding of it.
Right. And on receipt of the documents, if it is before 4 weeks, etc., I'll liaise with parties to look at a date for the formal hearing.
Okay.
So that's, at worst, that's going to be sort of after middle of March, but hopefully sooner, depending on when I get the documentation. Okay. In terms of a site inspection, as I said, I've visited the site and had a cursory glance at the area to familiarise myself. Do parties wish an accompanied inspection as part of the hearing process, or are you happy to rest on the fact that I've seen the site? Mr. Murray.
I probably defer to Laura and Helen on that one, and ask them if they wish an accompanying.
Okay.
Site.
Right. Mr. Thompson, what's your preference?
I don't think there would be a necessity. I mean, the guidance.
Yeah, you are very welcome to visit the site at any point if you wish to.
But any
no problem with that at all.
Yeah, any visitation of the site would have to be through the aegis of the hearing procedures, rather than parties just turning up and not being accompanied by myself. So I would want a formal site inspection, Ms. Thompson, if that was the case.
Yes, I mean, I'm happy to be represented at an accompanied site inspection if you feel that would be useful in terms of improving your understanding, particularly on the back of the information you've asked to be furnished on the day regarding the connection and the line itself. So if there is anything that goes beyond just the physical context and physical features, then certainly we're not opposed to that.
Yeah, I think it would be useful. Certainly from my own point of view. Okay, I think it's coming clearer now. So just to recap, I will do a note of this meeting and ask all parties to comment within 7 days on paragraph 66 to 69 to me and the other party, and then there will be a 7-day period to comment on that. Okay. I would ask for a statement on the planning position of the current use of the site and aspirations that may require planning permission for future uses of the site. If that was possible to get that within 7 days as well, just to keep the diaries clear. Yeah. And to both parties, so Mr. Murray, yours to Mr. Thompson, and vice versa for comments on that. I'd like a statement just on the technical aspects of connecting to that 33 kV facility, and comments from Scottish Power on the suggestions made by Mr. Murray about those other examples whereby someone is getting a supply from a 33k facility. Okay, is it possible to get all that information within 7 days and then to the other parties for 7 days? Because after that, after that 14-day period has expired, I would then want receipt of all final documents in terms of the hearing statements and documents associated with that. And again, I'm conscious of wanting to get the hearing established as soon as possible. Would that latter assembly of information be suitable within 4 weeks of today from both parties?
Sorry, I wasn't aware you were looking for a statement on the possibility of the electrical connection rather than just to be addressed, or to be addressed on the day. So you're looking for something in writing.
What? Yes, because I think that it is a technical matter, and I would want to be familiar with that. Okay, and just the potential of and the difficulties of connecting the 33 kV system to the facility at Newlands Farm. Okay.
Would it be possible for us to submit a document on that as well?
Yes, it would. I would want all the information in front of me about the pros and cons, the technical difficulties, and the requirements of Tweed dogs linking into that system.
Okay, thanks.
Sir, I don't want to stray into the merits, but what really is before ministers is whether it's necessary expedient to retain the existing line. The potential for a connection to that line is really a quite separate matter. And I know we have touched on it for completeness, but it's not the question before ministers in this case.
Indeed, but it certainly is background to me to understand the wishes of the appellant, and I need to know the technical aspects of doing that, and I would just like it as background information. Okay.
I think you just, I know we're not discussing the merits of the statements and getting into an argument today, but I think probably with the comments on paragraphs 66 to 69, there will be a little bit of interconnection where this is actually addressed, because from SPD side, they think it's a separate entity, and from our side, we obviously think it's site-specific and material consideration. So, yeah, I think the documents to be submitted on those paragraphs may well help draw out the positions and clarify them from either side.
Mr. Thompson.
Well, as I say, it's not, you know, as a matter of law, it's not relevant to the question, but it is background. I would have to defer to Mr. Gavigan as to what timescale he would need to pull that information together. So I don't know if 7 days would be sufficient.
No, we can pull something together in 7 days. Just so I'm clear, you want to understand, is it technically possible to do it, and what are the pros and cons? Is that the question?
Yes.
So we can pull something together on, the technical side of it, the pros and cons, and why it isn't formed part of our policy, and so on and so forth.
Yeah. I mean, you'll see from paragraph 66 to 69 in the document, there's a clear description of the purpose and scope of the reporter's consideration. Okay. Taking the point that Mr. Murray has said, maybe if he wishes, he could put his case in his response to that, and similarly, Scottish Power could put their case in response to my questioning on 66 to 69. It's a matter that's been raised, and I'm conscious of what's before myself in recommending to ministers, but I would want to be fully understanding of the position of both parties in the context of paragraph 66 to 69 on this issue of the technicalities. Okay.
Understood.
So if parties so agree, in the statement of response to paragraph 66 to 69, reference is made to the technicalities, and obviously either side has the 7 days to comment on what the other points have made. Okay. Right. So the only other information in that case I particularly require from Mr. Murray is a description of the planning status of the site and planning aspirational status of the site, and parties can comment on that.
Yeah.
Okay. Mr. Thompson.
No, that's fine. The only thing we haven't touched on is duration. Is it too early to give an indication of what your thoughts are regarding the likely duration of the hearing?
Well, I think there's a lot to discuss, even in the confines of paragraph 66 to 69. I would like to think we can do it over the course of a day, but I would certainly like to have the facility to overrun if that happens. Mr. Murray, how do you find your thoughts in terms of length and duration?
I think it'll take what it takes, and it'll run its course. And I suppose you're the reporter making the decision, and you need the information. You need to be satisfied that you have the information to be able to make the decision. So the ball is kind of in your court in terms of how long it's going to take.
Well, Mr. Thompson?
I think given the extent of this sort of front loading, I would like to think that it wouldn't extend more than a day. I mean, on the basis that the hearing is essentially to try and plug any gaps and to allow you to properly understand the position of the parties. I mean, I think the issues in dispute are actually quite narrow in this case.
Well, what I will do is I will certainly book a day. It's not going to be a half a day case, but with the option of overrunning the following day. Okay, we can get my assistant can get dates around parties probably sometime in the middle of March for that, depending on when the completion of all the prior circulation is complete. But sometime in the middle of March, which is about 4 to 6 weeks away.
And can I ask, do you envisage the hearing going ahead in person or by Teams at that stage?
My preference is for it to go ahead in person, but I think it's quite a complicated answer to find to that question, because our regulations change so much and so often, and obviously a lot depends on matters far beyond my control. But I would certainly look to arrange it virtually, and if we can have it in person. I mean, does anybody have specific wishes to have this in person rather than a virtual meeting hearing?
Well, I think it would be more efficient in person, but equally, it's possibly, if we're looking at that timescale, it's possibly too soon. But yeah, I think we'll just have to see how things evolve.
I think we've just got to see how things are. I mean, certainly the latest guidance from DPEA is that we stay to the virtual sessions as things stand, with a view to having some dual hearing process if necessary. But I wouldn't like to say we'll definitely have an in-person hearing in 6 weeks' time, because we just don't know what's going to happen in a much bigger picture. But what I'll do is once we get a note of the meeting round and everyone's concurred with it, I look to getting 2 days blocked sometime in the middle of March for the hearing, because I certainly want the ability to overrun if it can happen within a day, all well and good. But I would certainly want that facility. And then I would look to having the company site inspection after the hearing, in case matters are raised at the hearing and I need them pointed out on the ground. Okay. But I think it's very important everyone is aware of the content of paragraph 66 to 69, and I'm looking forward to receiving those views at this time. Any other relevant matter that any party would wish to discuss at this point in time?
No, I think so.
Okay, well, I think if that's the case, I'll just bring this pre-meeting to a close. And can I thank you all for joining? And I hope with Helen Thompson that you've been able to follow it as best you can on a mobile phone. You have? Good.
Yes, thank you.
Good. And I'll do a note of the meeting and circulate that hopefully by the end of this week. Okay.
Thank you.
Thank you.